Prada. They have their different identities in their logos, in their styles. When it comes to Louboutins, of course, we see the red bottoms. And you know, okay, this particular style belongs to this particular kind of brand. So you know that these is an identity for those kind of brands. Now let's move to sports. Over the years, sport athletes have become sport icons. We have someone like Simone Biles. Simone Biles, I think, was with Nike at a point as an ambassador. So we have different sport brands that cover up in the fashion space. We have Adidas, we have Nike, as I mentioned already. That tells you that the intersection between sport and fashion cannot be overemphasized. Like I said before, that's a union that has stayed before time and remain for a long time because let's consider the sport fans, even the athletes, the outfits they wear. When you hear the Red Devils, when you hear the Blues, what comes into your mind? Okay, this particular club, that particular club. When you look at the colors they wear, what comes into your mind? This particular club, the logos they have. Then different clubs. Lately, you see different amazing merchandise by several sport icons, by several sport fans. That tells you that the fashion space it's so embedded in sports. Like I said, fashion is an expression of identity. Sports too is also expressing identity when it comes to national sports identity in your country, in your state, in your division. When it comes to sports, like we have the normal sports around the world, Arsenal, Chelsea, Manchester United, Manchester City, all these different sports clubs also have their identities. So, what way would they express this identity? Fashion has come in. You can express them by the things they wear, the way they wear them, and the way they express them. So, if we can enjoy the fruits of all this labor, there comes a big question. How then do we protect this? Ladies and gentlemen, that brings us to what happens when fashion and sports intersect. What can be the protection? What can be the defining factor? That is where IP comes in. IP says, hold your horses. We can protect something. We can protect your logos through trademarks. We can protect your slogans. We can protect your marks. We can protect your names. We can protect even your colors. IP says all that. And also IP says, oh, there are different forms also in sports. We can also protect them through industrial designs. There's some copyrights too embedded in sports. We can protect them as well through copyrights. Then fashion says, okay, if we're going to express fashion in sports as well, how do we protect them that someone without my license would not probably infringe on my rights? We have very overzealous fans. Go to the Olympics, for example. The Olympics, you see several merchandise flying all around, fashionable pieces. And then there comes the question, how then as a brand do I protect my name from being exploited by those who are in the fashion space from using it? Icons, we have several fashion sports icons. For example, Messi, Ronaldo, their faces have gone through a lot in the hands of some overzealous fans. You've seen so many merchandise with different faces of sports icons. So people actually get them. There comes the question: are these icons even aware that their names are on this merchandise? Listen, gentlemen, these and many more we discussed the between fashion and sports. And when they intersect like this, what does IP say? I will be doing most of the talking today. That's a way of a welcome address to what we'll be experiencing and expecting from today's session. We have some phenomenal powerhouses who will be doing the speaking for us today. One more time, welcome to World IP Day for 2026. It's the webinar. It's our IP hangout here at Fashion Law Institute Africa, and it's going to be quite a phenomenal day. This year, we're always in statics when we're thinking about IP. IP has come, it's changing the game, it's recreating the game for us. And we as Africans, it's our job because our fashion is our expression, is our identity. At this point, I want to move on to our keynote speaker for today, ladies and gentlemen. I was going through her bio, and as usual with the Institute, we make sure that we bring the best of the best to speak with us every time. And our keynote speaker for today is no exception at all. With a very phenomenal bio that I'll be reading out in no time, we just listen and get to know more about this amazing lady. One more time, welcome to today's webinar, and I hope that you have quite a remarkable time. Okay, our keynote speaker today is Sarah Ochwada. Sarah is a retired runway model turned international sports entertainment, and fashion lawyer, and is the founder of Sports Fashion Law, a pioneering framework that bridges sports codes with fashion industry regulations, aligning legal structures with cultural influence and economic realities. She serves as vice chair and judge of the Player Status Chamber at FIFA, where she contributes to the adjudication of global football disputes. She's the first Black African woman to obtain a master's degree in international sports law. Her work spans dispute resolution, athlete representation, regulatory design, and policy development, with a particular focus on how legal and institutional frameworks shape value, rights, and access within sports. She has advised and represented athletes in proceedings before international bodies, including the Court of Arbitration for Sports. Sarah's practice extends into the creative economy, where she advises athletes, creatives, and institutions on intellectual property, contracts, governance, and commercial strategy. As principal counsel of Snow Legal, sports entertainment, she leads financial justice and contract literacy initiatives designed to enable talent and their teams to negotiate, structure, and retain value in high stakes environments. Sarah is a published writer in fashion law with contributions. Okay, sorry, I lost my network there for a minute. Ladies and gentlemen, with various contributions so far to the fashion space that has made her a name and someone to reckon with. I would not go so much into this because she's here with us and she's ready to wow us. Ladies and gentlemen, the first Black African woman with a master's in international sports law. What does that tell you? It means we've brought the best of the best. Please, I'll give the floor now to our keynote speaker, Sarah. She gives us a phenomenal keynote. Hello, Sarah. You're welcome to today's session. Please, the floor is yours. Do have a wonderful time giving us your keynote address. Thank you.
Hi, good morning. I think it's morning your side. It's now afternoon in Nairobi, Kenya. It's so good to see everyone. God's love, I love your name, first of all. It's beautiful. And I love your shirt. So happy you're representing the African pride. Today I decided to wear something sporty. I'm in a tennis outfit for the day because we're talking about sports and fashion. But what I want to say is that whether you're a practitioner or an enthusiast of either sports or fashion law, I hope I can expand your mind with my presentation today and open your boundaries to practicing this new area of sports fashion law. So that being said, let me see if I can share my screen. I've prepared a little presentation for you guys. Let's see. I hope you can see that. Okay, okay. I'm just trying to make sure it's showing the right thing and not my notes. One moment. Sorry guys, I'm a little technologically challenged. Fit to screen. There we go. Okay. seeing the PDF, or PDF is on? Thumbs up if you can see it. No? Okay, let me try again. Sorry, guys. How about now?
From my end, it's still coming up, so I'm still waiting to have it up. I don't know if anyone else can see the screen yet, please.
Okay, let me know, because I can barely see anyone else. I'm trying to operate my screen, looking back, but yeah, if you can see
Okay.
it, let me.
It's
Okay,
up now. Yes, it's
fantastic.
up now. Yes.
Yes, I can see your screen.
Okie dokie. So, what is sports fashion law? And here we're starting with a general definition, because traditionally when we think about sports fashion, we think about kits, shoes, and performance gear. But today that definition is going to expand a little bit with what we're getting into, because we're looking at the beauty, the innerwear, the digital presence, which is combined together with the sports ecosystem in very exciting ways. Now, sports is governed in several different layers. And although sports and fashion are natural allies, every sport has its own unique code of dress. And every outfit in sport has its own bundle of rights, and IP is the underlying thread that stitches these bundles of rights together. So, while we look at the definition of sports fashion law, we have to look at the three-layer framework, which is within the sports ecosystem. You have the individual, who is the athlete, the club or the team, and then you have the national federation. And across these three layers, you have different rights and obligations where conflicts can emerge. So, for example, when you have in football, a single athlete can simultaneously represent multiple brands individually at club level and at national team level. And these are all governed by different rules. So here you have an example of Cristiano Ronaldo, who is signed as an individual Nike athlete. But when he was at Real Madrid, he could wear his Nike shoes while at the same time wearing the kit, which is Adidas. But when he moves on to the national team, there was a year when the national team kit was being supplied by Puma. So those are three different conflicting kit suppliers or kit sponsors. And all these different relationships had to be governed by contracts because they all involved image rights related to this particular athlete. Now let's look at the fine print. Within sports and fashion, there are two essential stems which we're looking at. You have the intellectual property, which governs those designs which are made for the kits, technologies such as wearable tech, and branding such as the logos and trademarks. But you also have something called NIL, which is name, image, and likeness, which governs what the person is wearing, together with their identity, which is considered as a commercial asset. So when you look at the name, image, and likeness across three layers, you have the individual level, where you're dealing with personal endorsements, personal branding. You have the club level, which deals with kit sponsor obligations, media rights, and commercial appearances. And you have the national team level, which deals with federation sponsors, tournaments, branding rules, and Olympic game restrictions. Now, we've already seen an example of a footballer who has 3 different concurrent rights with 3 different brands. But when you look at the NIL at the individual level, if you have a boot sponsor, for example, Nike, and if you have a club level sponsor, for example, Adidas, and you have a national team sponsor, such as Puma, then you have to manage very delicately the bundle of rights that each of these sponsors is going to walk away with. Because it's not just enough to own these rights, you also have to control them. And what each sponsor wants is visibility and the value given by the athlete or the professional sports person. Now, not all sponsors control the same rights. Kit sponsors control the product and hold the design rights for a kit, whereas a commercial sponsor controls the space on the product and holds the advertising rights when it comes to a kit. In other words, for example, if you have the team known as Arsenal, their kit sponsor is Adidas. So Adidas is in charge of the design and manufacturing of the kits and the fan replicas, whereas the commercial sponsors, you could have 2 on one jersey. For example, you have Fly Emirates, which is across the chest of the jersey, and you have a sleeve sponsor, which is Visit Rwanda. And by the way, these 2 sponsors can exist concurrently because they are different categories of brands. Fly Emirates, airline; Visit Rwanda, tourism. But both of these are commercially viable sponsorships, which makes a jersey or a kit to be a commercial asset for a team. In the same vein, you have kit sponsors and commercial sponsors in motorsport. But the biggest difference between football and motorsport is that kit sponsors in motorsports are attached to the engineering team as well. Reason being, a race suit has to reach the technical desirable standards for safety within motorsport. So a kit sponsor who is in charge of designing the racing suit has to be at the level of designing a suit which is suitable for the motorsports safety, the safety of the driver within motorsport. And it was just not just the kit itself, but also the headgear which they wear, the helmets, and their shoes as well have to have specific requirements within the motorsport regulations. And all these are governed by the regulations in safety for drivers within sports. On the other hand, you have commercial sponsors within motorsports. And if you have noticed, a lot of drivers look like they are a walking billboard. They have so many brands across their suits, their race suits. It's because the suit itself is for product placement, and all those brands hold advertising rights on the suit. Now, where you appear on that suit depends on how much you pay for visibility. So you purchase visibility and placement on the kit and also on the car which the driver is going to be racing with. Now, intellectual property and image rights also breed conflict, especially when you're managing a variety of contracts within sport. Now, one of the conflicts, or some of the conflicts I'm going to highlight, for example, in football, is ambush marketing. There was a fellow known as Nicholas Bentner who once upon a time decided to celebrate a goal by revealing his boxer shorts. And across the boxer shorts was written Paddy Power, which is a betting company. Now, Nicholas Bendtner was given a disciplinary fine for that stunt. And it actually evolved the rules concerning sporting wear and what you can display during a match on the field. So number one, it wasn't just ambush marketing because the sponsors had already paid for visibility during the match or during the game. But also he was fined because Paddy Power was a betting company which had not bought rights to be visible during a live match of the league. So he was fined, and now there are very strict rules about what you can wear, and even goal celebrations, you're not allowed to remove your jersey or remove your kit or display anything which is not an allowable kit on the field. So that's Nicholas Bendtner. You have another very interesting case of Peter Cech, who was a goalkeeper, and he had a head injury. Now, because of this head injury and to guard against concussion, he started wearing some headgear to protect his skull. But initially, the headgear was not part of the kit. In football, a kit is a controlled asset, which is if your jersey, your shorts, and your socks are part of the kit, the boots are separate. They're not considered part of the kit according to football regulations. But in this case, Peter Cech had a very unique position because headgear is not normally worn in football. So he picked any headgear which was available to him. But in order to accommodate the sponsor value for the kit manufacturer, which was Adidas, Adidas had to design headgear specifically for him so that there's no conflict in the kit sponsorship deal which he had with the team. In sports, you also have a lot of protests and defiance. For instance, during the 1996 the Los Angeles Olympics, which took place in 1996, there was a dream team of the NBA, which was composed of players from the NBA, which included Michael Jordan. Now, unfortunately, because these NBA players had been signed on to different commercial sponsors with other apparel giants, their national kit sponsor was informed that if this winning team appears during the medal ceremony wearing your kit, they will have breached their home apparel contracts, which they had signed previously. So in order to go around this conflict, they wore flags to conceal the branding of the kit or the branding of the kit manufacturer. So it wasn't so much that they were being patriotic with the flags around their shoulders, it's that they were told, if you appear on the podium wearing a different logo than that which you have signed on to, it will lead to severe consequences, which you do not want. So they took their flags and wrapped it around their shoulders to conceal the kit. But of course, now this led to another evolution of contract negotiations where you have the different layers of image rights and kit manufacturer rights and visibility, so that those who are having sponsorships with their home teams or home clubs or individuals are given a grace period within which you can actually wear your national team kits without any repercussions for a short period of time. Moving on to someone who's even just as interesting, Serena Williams wore her catsuit during a tennis open. And unfortunately, tennis is also highly regulated in what you can wear during competition. And some venues and some tournaments are more strict than others. For example, Wimbledon, it actually restricts players or tennis players to wear white. And the only thing you can have is maybe a color around your collar, very thin color or stripe around your collar, but you're required to wear Wimbledon whites. That's what they call them. But now, for Serena's case specifically, she had worn a cat suit because she was undergoing some medical treatment and she needed her lymphatic system to hold up. Unfortunately, that went against the tennis regulations and she was fined heavily for it. And thereafter, she came back with a tutu. She wore a tutu after that because she thought, well, the regulations are not very helpful because she had a medical condition. But that being said, she decided, you know what? I will just use my creativity. There's no rules against wearing tutus, so I will appear on the tennis court wearing a full-on ballerina tutu. Now, when it comes to culture and identity and beliefs as well, we've had very many issues coming up with whether or not Muslim women specifically, are allowed to wear hijabs when they're competing in sports. And specifically, I think in France, there was a regulation against the wearing of hijabs, which affected a lot of French nationals who are of hijabi heritage. But even so, there's a lot of sportswear and a lot of fashion innovators who are coming up with hijabi-inspired sportswear, and you can see more and more people are embracing these different forms of creativity to allow modesty within sport without also infringing on the freedom of religion of the women who are participating in the sport. When it comes to heritage and prestige, there are so many luxury houses which have involved themselves in heritage sports. For example, Hermes was well known for making saddles before it moved into bags and other luxury items. But it has always been close allies to equestrian sports. So wherever you see equestrian sports, you will also always almost see Hermes right beside them. Likewise, sailing is an elite sport which uses chronometers or very fancy sports watches. And you'll find names such as Rolex or Longines, and they do a lot within the elite sailing space, such as Sail GP. Now, when it comes to innovation, innovation is only acceptable up to a certain point before the governance regulations in sports come in to halt them. For example, when it came to swimming, Speedo, a very big brand when it comes to swimming, came up with a swimsuit known as the Laser Racer. And it had the type of fabric technology that would repel water and therefore reduce the kind of friction a swimmer would have during competition when they're in the water. Now, this Speedo Laser Racer was responsible for very many world records being broken. And for that reason, FINA, which is the International Aquatics and Swimming Federation, decided that when it comes to fabric technology, the Speedo Laser Racer would not be allowed during competition because it gives an undue advantage to those who can afford it compared to those who cannot. And so they needed to make sure that everyone was competing at the same level, and Speedo would not be allowed to give competitors, or competitors would not be allowed to wear Speedo Laser Racers during competition. Likewise, in athletics, we had a shoe known as the Nike Vaporfly, which was banned from the marathon. because the technology which was used to build this shoe or to create this shoe was such an innovation that it literally made athletes feel like they are flying down the track. I think they made it out of some carbon fiber and some other materials which were considered to be prototypes. Now, World Athletics has commercial regulations and shoe regulations and kit regulations, which restrict athletes from wearing prototypes during official races. So for this reason, if you have any ambition to run in athletics, make sure you're running with the right shoes and not any prototype shoes. Otherwise, you might run the risk of being disqualified. And this actually happened very recently to one of our Kenyan athletes who bought shoes just last minute, wore them to a race, came in seventh place, but was disqualified because they were prototype shoes. They were not allowed during competition. However, the shoe manufacturer decided to grant the athlete the money that he was otherwise denied because of disqualification. And so that was a very feel-good story for the athlete in that case. And it also gave a bit of mileage to the shoe manufacturer who had made that prototype. Now, you can't fashion without talking about ethics and sustainability. So it's not enough to have beautiful garments and replicas for fans and technical kits for athletes and sports people. More and more, we are looking at those who are going to be buyers of these kits and sportswear, asking, are those fabrics responsibly sourced? Are they ethically made? And are those who are making it being compensated fairly? So FIFA recently got into an agreement with the World Trade Organization, and what they have is an MOU between FIFA and those countries in Africa, which are cotton producing countries, to create cotton, which will be then made into fabrics that will be used for the FIFA Forward programs for schools. So any school program which is funded by FIFA, the uniforms for those players and those children actually comes because of this MOU between FIFA and the WTO cotton agreement. So that goes into ethics and responsible sourcing of the fibers and fabrics. On the other hand, ethics and sustainability has its limits, especially when it comes to certain sports such as motorsport. Now, fun fact, motorsport race suits have an expiry date because you can only wear it so much before the wear and tear renders it not as useful in case of things such as fire hazards. And I don't know if there's any motorsport fans in this room today, but sometimes you can get into a crash and a fire occurs during the race. So the suits have to be fire resistant in as much as possible. And so then it must be changed out every so often and replaced time and time again. So whereas you have in football, you have ethics and sustainability to ensure the ecosystem is not full of garments which are going to be tossed aside. In motorsports, the sustainability is not quite as much as it is in other sports, because you have what is known as controlled obsolescence, meaning these suits are actually designed to be used for a short period of time. Beyond that, and this is just for FYI, you have quite a number of companies in sportswear which are now trying to come up with developments to extend the life of fan replicas, because every season the kit manufacturer must create a special design for the home and away kit with different colors and what have you. And of course, fans want to have the most current of the season's replica to support their teams. But now what teams are doing when it comes to sustainability, because you don't want to keep selling new season replicas, they're trying to find ways to extend the lifespan of every season's team jersey. Okay. Last but not least, and this is very exciting, we have cultural and commercial crossovers in sports fashion. For example, Fenty Beauty was the official sponsor for the medal bearers and the ushers at Paris 2020, when was this? The Paris Olympics. And what she did was a very clever way of introducing beauty into the sports space, because a lot of these medal bearers, those young people who are carrying the medals, are visible, but no one had ever thought of sponsoring them. So Fenty came in as the beauty sponsor to provide makeup for the ushers and the medal bearers. Skims. Skims had a Team USA collaboration where they provided the innerwear for the Olympians who are coming from the United States Olympic Committee and representing the USA in the Paris Olympics. And then you also have now a crossover between sports and the digital divide, where you have streamers such as iShowSpeed who are creating content around sports and football, but now it's expanding the regulation of global sport, because there's a gap between the NIL for sports athletes, but there's also image rights and related rights for non-traditional actors within sports, such as streamers. So if someone asks you, what is sports fashion law? Sports fashion law is simply a system of rules which governs sportswear that interacts across law, commerce, identity, and sporting regulation. And that is it for my presentation. I hope you have enjoyed it. I'm open to any questions. I know it's a lot to think of for now, but I really wanted to explain to you that this is such a rich, in-depth, and wildly beautiful area that you can combine, which is sports, fashion, and the underlying intellectual property. Thank you.
Thank you so much, Sarah. I was listening, and trust me, I was writing. It's first of all, I would commend you. You speak so amazingly, really, really well. You're an amazing teacher. Everything you said, you took it carefully. Your slides were beautifully done, straight to the point. That was astute. Sincerely, that was really amazing. I would say anyone who has missed the keynote address has missed quite a lot. I've written quite a lot. I think getting a new understanding of NIL, that was really nicely done. Thank you so much. Great job. And then understanding the power of visibility when it comes to sports, and basically how these fashion brands who get involved understand that they are buying visibility and value through these athletes. So if you're doing that, what are those negotiations? What are those partnerships that come in? You spoke about ethics and sustainability. It done that. Indeed, there are some things that probably in the IP space, we're looking for these innovations. It's quite beautiful. We want people to innovate things so they can probably patent them and all that. But then while they're expressing their innovations, they're also the part of ethics and rules that protect a particular form, like sports. So what happened with Speedo, and knowing that while IP pushes you to express in the space of fashion, creating new things, sports also has regulations to create an even field for everyone. That was nicely done. And finally, hearing about Rihanna and Fenty in your presentation, that was quite amazing, knowing that it's not just about the sports itself. There's the players who are involved, not just the athletes themselves, also linesmen, children, fields persons, those around. No, that was spectacularly done. And I'm sure that everyone here today has had quite a good understanding on what you said about sports, fashion, and that intersection. So looking at those rules that govern sports law and how, of course, it interacts with fashion and looking at identity. Thank you so much. Thank you. At this point, I want to go on to ask for questions. So, ladies and gentlemen, okay, I already see some questions in the chat box. Please, if we have more, let's bring the questions in. Okay, so we can go through them. I'll just go through. I already get some questions. Okay, I think this is from Rejoice. Rejoice says, "Hello, ma'am. Thank you very much for an insightful keynote. My question is, in collaborations between fashion brands and sports organizations, who typically owns the IP? Great question. And what are the common pitfalls in structuring these agreements?" Over to you, ma'am.
Ooh, so I'll give you a very legal answer. It depends. So it depends on who owns the underlying product. So for example, if you are a sports kit manufacturer such as Nike, and you're providing kits to an Olympic team, for example, Team Kenya for marathon runners, Nike insists that the design of any team uniform for Kenya is restricted to Nike. We can't even sell replicas to other Kenyans. All that belongs to Nike. However, if you have a different contractual relationship, for example, if Adidas comes in as the sponsor, the lead sponsor for FIFA as an organization, for instance, then FIFA will give them specific things, which is based on their needs. They will give them uniforms for their volunteers. For example, if you're going for the World Cup or if you watch it, you'll see there's quite a number of volunteers. They're all kitted by Adidas. They will give you shoes for all your officials. Whether you're wearing a suit, your shoes must always be Adidas. So that relationship, the IP still belongs to Adidas because the shoe itself is protected by design rights and industrial rights, or even now the design of the kits which you're giving to the volunteers, whether it's the combination of colors or even just the different collars or shirts or whatever it is, still belongs to Adidas, meaning you cannot replicate that design. But if you're in a club situation, or you, let's say, are the very fabulous Serena Williams, and you decide, let me just go to someone who can design for me a fabulous looking tutu so that I don't have to wear these regular looking tennis clothes, then that design becomes a work for hire, and she can actually put it in the contract to own that design so that no one else can own it or replicate it, and it becomes her signature design. So yes, it depends. It really depends on who has the most superior bargaining power when it comes to manufacturing of kits. So I hope that answers Rejoice's questions.
Okay, thank you so much, Rejoice. Please comment in the chat box. I hope that did justice to your question. We have a question from Regina. Regina is asking, how does fashion law come to play in the digital space, such as virtual world? We've seen avatar gear that's sports themed. So how does sports law come to play in the digital space, such as virtual world? We've seen avatar gear that's sports themed.
Yeah, it's so interesting, especially now with AI, where you can actually feed information into AI and produce a design which looks like, it kind of sort of looks like Louis, or it kind of sort of looks like Chanel, but it has your maybe an African spin. So in the digital space, fashion is expanding in a way, let me put it this way. The next thing you will look for is something called provenance. Now, provenance is an art law term where you have to prove the origin and the ownership passing of title from one owner to the other, so that you understand where the inspiration came from. So if you're in a digital space, the next thing we're looking at in law is provenance. And provenance is, can you actually trace back to the origin of where this inspiration came from, so that the person who was the originator of this idea does not get their rights trampled on. So that would be my next best thing in the digital spaces.
Okay, thank you. Moving on, Abayomi is asking, please, is controlled obsolescence a sustainability practice, or is it more economically oriented? Please, is controlled obsolescence a sustainability practice, or is it more economically oriented?
Okay. So this is in regards to motorsports. Controlled obsolescence is actually for safety regulations, because if you are handling a machine such as fast car, you have the crashing or getting into some sort of fire, then you have to make sure that whatever gear you're wearing will be able to repel at least some of the injury which is caused by that fire. So controlled obsolescence means that you can only wear something for so long, and then you have to replace it. Otherwise, you might be wearing something which is 20 years old and will not be able to save you from the risk of fire or any other injuries which are related to your motorsport.